My lady, can I return briefly to two matters? Firstly, dealing with the point raised at the outset by my Lord Sales. I've had an opportunity to discuss the matter briefly with my learned friends. They, of course, will speak for themselves insofar as it's necessary to do so. But as I understand the position, although there is, of course, a dispute in this case as to the scope of the right of appeal, which is central to the case. Nonetheless, there is no dispute based on any lack of authority of the OV to act on behalf of the FSA, or in any distinction to be drawn between the FSA and the OV as such. If that as it were, disposes of the point, and if I can rest content at that juncture, then of course I'm happy to do so. But in deference to the points that Lord Sales has raised, and unless I'm told it's unnecessary to do so.
Well, I mean, if it's common ground, I'd have thought that Sir Alan will explain to us why he's made the concession. So why don't we leave it to him?
Yes. I'm happy to do that, and if necessary, I can return to the point in my reply. Then, thank you very much, my Lord. That's helpful. And the only other thing is, if I may, to distribute to the court copies of the relevance parts, particularly sections 116 and 117 of the Public Health Act 1975. I don't think I need.
I think you mean 1875.
I do mean 1875. Thank you.
And it also wouldn't surprise me if there hadn't been a predecessor to that.
There may have been a public health.
Well, there were public health acts.
Before that, yes.
Before that,
yes. This was the seminal one, as it were. Anyway,
yes.
Importantly, this was the one that was revoked and replaced by the 1938 Act.
Yeah, even as it's going round, I noticed this is an act for consolidating and amending the acts on public health.
Yes.
So,
yes, I have had occasion to look at this legislation in the past.
We've copied, in particular, sections 116 and 117, yes. Which are the relevant ones, and I don't think I need make any separate submissions on those, because the court has my points in relation to it.
Thank you. Thank you. Sir Alan.
May it please the court. My ladies, my lords, on the issue raised by Lord Sales, our position is that the OV acts for all purposes under the authority of the FSA, but when he's acting in the context of what I'm proposing to refer to as the EU fresh meat regime, under article, which is established by Regulation 854, he exercises his independent professional judgment. And the reference to the competent authority in Article 54 of Regulation 882 is concerned with the exercise of enforcement powers and would only relate to the OV to the extent that he was exercising such powers as he or she sometimes does. But it's our submission that Article 54, paragraph 3, doesn't in any event create a right of appeal or impose a duty of appeal on a duty on member states to provide for such a right, but that in any event it wouldn't apply to decisions by the OV under the EU fresh meat regime of Article 854. Lord, may I?
Thank you.
Is that sufficient? Thank you. With your permission, I shall address the appellant's primary position on the applicability of Section 9 of the Food Safety Act 1990 by way of Regulation 25 of the Food Safety and Hygiene England Regulations 2013 to a situation where the operator of a slaughterhouse disputes a decision by an OV on the unfitness of meat to be placed on the market and is unwilling to surrender meat voluntarily. My learned junior, Mr. Heppenstall, will address the appellant's alternative contention that human rights law requires that a right of appeal against such decisions must somehow be available. My ladies, my lords, I will make three main submissions. First, that recourse to the procedure of Section 9 would be incompatible with the special regime of Article 854, of Regulation 854, designed to ensure that fresh meat can be placed on the market safely, which I am referring to as the EU fresh meat regime. Secondly, the appellant's account of the relationship between Regulation 854 and Regulation 882 is misconceived. Regulation 882 provides no basis for a right of appeal against decisions of the OV under the EU fresh meat regime, and no basis for a duty on member states to provide for such a right. If I may begin with the incompatibility of recourse to Section 9 with the EU fresh meat regime as found by the learned judge and by the Court of Appeal, who reached the conclusions they did in the light of certain key elements of the regime. On these key elements, I can be relatively brief. First of all, because the respondent's understanding of the regime and its implications are fully set out in Part B of our written case, more particularly at paragraphs 20 to 31. I don't think I need to take you there at this stage. But secondly, and more importantly, because that understanding accords fully with the reasoning of the learned judge and of the Court of Appeal. The relevant passage of the learned judge's judgment consists of paragraphs 47 to 50 at MS 249 to 250, and the relevant passage of the Court of Appeal's judgment consists of paragraphs 67 to 69 at MS 220 to 221. I shall have to take you to that passage in due course. In the respondent's submission, the four key elements of the fresh meat regime are the nature of the official controls performed by the OV under the regime, the OV's monopoly of decision-making, the nature of the assessment the OV is called upon to make, and the training requirements for OVs and official auxiliaries.
But doesn't the suggestion of a monopoly, isn't that what requires to be proved? Isn't the whole point whether or not the OV has got a monopoly of the decision-making?
Lady, under the regime as set out in Regulation 854, every decision relating to the fitness of the meat up until the crucial point of applying of the decision whether or not to apply a health mark is a decision that has to be taken by by the OV.
Yes, but the question is whether everything stops there. So over how much of the process is there a monopoly? That's the question.
In terms of the regime in Article 854, the process does stop there. The question, the next question in my submission, lady, is whether whether Regulation 882 provides for a further stage, and it's our submission that it doesn't.
Or whether, if national law provides for a further stage, as part of the enforcement mechanism for the decisions that the OV does have to take, whether that is incompatible with 854. There are two questions.
Well, there are indeed, my lady. I'm focusing for the time being on the EU legislation, but of
Yes,
course,
indeed. And you had there was a fourth key element, and I interrupted you after number 3. So
that
if you'd
was
like to tell us what number 4 is.
yes, it's the training requirements for OBs and official auxiliaries. First, then, the nature of the official controls performed by the OB under the regime. The core purpose of those controls is to determine the fitness of meat to be placed on the market. The decision whether or not a health mark should be applied turns on the OV's professional judgment as to the condition of the meat. The issue is a binary one, and the consequences of the OV's determination are inexorable. If the OV finds there are no grounds for declaring the meat unfit for human consumption, the meat is given a health mark as its passport onto the market. There are no grounds for declaring it unfit. Then it's given a passport. If not, the meat cannot enter the market, except as a result of criminal activity. The health marking decisions by the OV may be contrasted with the determinations that have to be made for the purpose of enforcing food law. The purpose of such decisions is to verify whether a given FBO, food business operator, is complying with its obligations under food law, and if not, to decide on appropriate enforcement measures to remedy the situation, which opens up a wide range of possible actions. The OV does perform some controls of that kind. For instance, audits of good hygiene practice under Article 4, Paragraph 4 of Regulation 854. But that's different from deciding on the fitness of meat to be placed on the market, which is about the condition of the meat, not about the conduct of the slaughterhouse operator or the condition of the premises. If I may clarify one point, it's not part of the respondent's case, nor in our understanding was it found by the Court of Appeal that there is a crucial distinction between intentional and unintentional forms of non-compliance. The distinction for which the respondent contends is one between the professional judgment which the OV has to make about the condition of the meat and decisions taken in the light of investigations as to whether any action is necessary and what form that should take in order to ensure compliance with food trade law. I shall return to this issue in dealing with the applicant's arguments on Regulation 882. The second key feature is the OB's, forgive me, my lady, the OV's monopoly of decision-making. The point that I have I haven't developed it, but I have referred to it. Article 5.1 lists a series of inspection tasks which are developed in more detail in Section 1, Chapter 2, and in Section 4 of Annex 1. And these represent the steps in a process of determining the fitness of meat to be placed on the market, culminating in the decision whether or not to apply a health mark, as provided for by Article 5.2 and Annex 1, Section 1, Chapter 3. Nobody other than the OV, or for some purposes official auxiliaries acting under his or her responsibility, is legally authorized to perform any of that series of tasks, up to and including the application of the health mark. And it's common ground that Regulation 854 doesn't provide for a right of appeal against any decision of the OV in performing those tasks. A third key feature is the nature of the assessment the OV has to make. It's expressed by Article 5.2 as being that official controls have not identified any deficiencies that would make meat unfit for human consumption, or according to Annex 1, Section 1, Chapter 3, that there are no grounds for declaring meat unfit for human consumption. Would you like me to take you to those provisions?
Have we not seen them already?
You would have seen them certainly in the written cases.
We've also seen them, I think, in the course of this morning.
That's what I thought.
Yes.
Thank you.
The learned judge described this as a double-weighted negative decision. And at paragraph 68 of its judgment, the Court of Appeal expresses approval of that description. Perhaps, may I take you there? It's at MS 221. At paragraph 68, the Court of Appeal says that the judge was right. That's halfway down the paragraph. The judge was right, for if the OB is left with any doubt about the fitness of the meat in question, then a health mark cannot be applied. The Court of Appeal also expresses approval of the judge's explanation of the way in which the issue is framed for the OB, that it's, and it simply continues, that it's because the regulation is designed to give assurances of a high level of protection of human health and consumers' interest in relation to food. In other words, there's no need for a firm decision that the meat is unfit for human consumption. It's sufficient if there's something that could call into question the fitness of the meat. And the reason for that is to ensure a high level of health protection. The fourth and last of these key features consists of the detailed provisions on professional qualifications for OBs and official auxiliaries. These are in Annex 1, Section 3, Chapter 4. I don't think it would be helpful for you to take you to that. There are detailed...
Well, could you just give us the page reference?
Yes,
Because we haven't seen those.
It's MS, pages 860 to 865.
Thank you.
The Court of Appeal notes, and this is towards the end of the paragraph, of paragraph 68, the Court of Appeal notes that the same qualifications apply wherever in the EU the OV may be based and wherever the inspection may occur. By that means, the court goes on, the EU legislature has ensured that the official to whom the decision is entrusted is fully and properly qualified to make it. That's
In
right.
fact, the page reference is 856 to 860,
I beg your
professional
pardon.
qualifications of the OV. And
I do beg the court's pardon.
Yes, because the next section is simply about what the
they've got to do.
inspections are
Yes.
to entail.
Yes,
I beg your pardon.
worry not. I just wanted to look at them.
To sum up on those features of the fresh meat regime, the OB is called upon to judge the condition of the meat, not the conduct of the slaughterhouse operator. There's nothing in the regulation to suggest that the final say as to whether meat can safely be allowed onto the market should belong to any authority other than the OV. And it's not unreasonable that the OV's decision should be final. This chimes with the weighted double negative character of the decision as one suitable to be taken on the basis of professional experience and trained professional judgment, and one might add professional intuition. It's also...
Sorry, just on that, as was canvassed this morning, I mean, presumably, at least theoretically, judicial review would lie. I mean, if the OV applied the wrong test, was too generous to the FBO, that would be a ground of challenge, wouldn't it? Or if they were bribed or something like
Indeed,
that.
my lord. Yes. Now, it's no disrespect to the magistrates' court system to say that a right for a slaughterhouse operator in the event of a dispute to have the issue taken before a justice for the peace for determination would be inconsistent with that legislative scheme. Of course, magistrates are accustomed to resolving difficult technical issues by assessing the relative credibility of experts on either side of the argument. But that's simply not the kind of decision which is contemplated in the legislation. In our submission, a clear choice was made by the EU legislator in favour of a regime based on professional decisions by specially qualified experts.
Well, given that we had a different regime before the EU regulation, which did provide for the possibility of challenging the judgment of the inspector, do we have any indications from the travaux préparatoires or whatever of the EU legislation to suggest that they were planning to take away rights which had previously existed in this context? Because we've had controls over the supply of meat for a very, very long time.
But Lady, I will deal with that issue when I come to the legislative history, if I may. It's the respondent's position that although provisions on the inspection and marking of carcasses might have existed for many years at the same time as an Article 9 type of procedure, there's no evidence, and my learned friend has been unable to place any evidence before you, that the article, that the latter procedure was used to dispose of meat that meat in respect of which the OV or his predecessor had refused to apply, to which he or she had refused to apply.
Apart from the fact that it was contained in the official guidance emanating from your client, which may very well be some indication that it actually was done.
But
I agree that we don't have anybody saying, well, I remember, there was a beast number 78 was condemned and we disputed that and off we went to the Darlington Magistrates Court or whatever. I don't think we have any evidence to that effect, but we do have the indication that that's what the FSA thought was the law, and therefore instructed its OVs to do accordingly.
the guidance,
Some evidence.
my lady, is, in our submission, legally incorrect. I have done my best to obtain instructions, but failed as to when the incorrect guidance was first applied. We know that it ceased to be applied shortly before the proceedings in this case were lodged, and in this respect, may I direct you to to points 11 and 12 in the Statement of Facts and Issues. If I may now move on to my second main submission.
Before you move from this, could you help me in really simple terms to understand why the OV is treated differently from any other form of official control within the regulation? The regulation that talks of official control, is that contemplating not just inspecting, but doing something about it as well? That's the first of the questions.
And the reason why in our submission he is treated differently is because of the nature of the decision that he has to take, which is...
Well, it's really the words. Where in the words of the regulation do I get the marking out of the OV? So the first question is, does the regulation, I'm looking at 854 at the moment, which is at tab 3. Does it comprise both inspection and doing something about what is found out? Inspection and enforcement, if you want to use those terms.
It does, my lady, where it's...
So official controls don't just involve inspecting. It's the competent authority under Article 4.2 that carries out official controls. One of the ways it does it is by Article 5, having an official veterinarian carry out inspection tasks, and that's what leads to the health marking in Article 5.2.
Yes, my lady, but there is a distinction in Article 4.3 between audits, which are controls that require regular checking on compliance with food law and taking any appropriate action, and the official control specified in Articles 5 to 8. Now, so far as fresh meat is concerned, Article 5 is the relevant provision which lays down specific controls applicable for the purpose of ensuring that fresh meat reaches the market safely. And those are laid down in part by Article 5 and in part by, and developed in Annex 1. But there is a distinction.
They include the OV, but not just the OV, is that right?
I'm sorry.
They include the OV, but not just the OV.
The official controls in slaughterhouses are carried out by the OV. That's in Article 4, paragraph 7.
Well, your point is that Article 4 is about audits, basically checking from time to time that people are doing things properly in a kind of general way.
Yes, my lady.
Whereas Article 5 is about specific carcasses, basically,
Yes, it's about
and checking that they're okay. And
checking
you
out-
say there's a distinction between the two different types of activity.
I do submit, my lady, that there is a distinction between the judgment which the OV has to make when deciding whether or not to allow fresh meat onto the market, and the judgment that's made as to whether conditions in a given slaughterhouse are compliant with food law.
The process under Article 5 has to be applied to all fresh meat, am I right?
It does, my lord, yes.
Whereas the audit checks under Article 4 are spot checks.
They are spot checks. There is a distinction between, as your lordship says, spot checks, which are carried out on a regular basis, but the OV's duty under the EU fresh meat regime, which is to check every single carcass before it's allowed onto the market, and if he isn't satisfied that the test prescribed by the regulation is satisfied, the meat cannot enter the market, and that's the end of the matter. If I may,
Well, how is it to be prevented from entering the market? This is to follow up my lady's question.
I mean, it's prevented from entering the market because there's a duty for the slaughterhouse operator to dispose of it as animal byproduct. It's our submission that the decision by the OV not to apply a health mark doesn't call for the remedial or enforcement measures that are referred to in the appellant's written case. The decision, the slaughterhouse operator is automatically prohibited by Article 5 of Regulation 853 from placing the meat on the market. May I show you that? It's at MS page 757. I've got it right this time. Yes, it is. Article 5, paragraph 1 says, food business operators shall not place on the market product of animal origin handled in an establishment subject to approval, which of course a slaughterhouse is, unless it has either a health mark applied in accordance with that regulation, or it's one of the cases where an identification mark suffices. So the meat may not, the slaughterhouse operator is prohibited from placing the meat on the market.
Yes, but how is that enforced?
Well, it's
Every rule that stops somebody doing something that they would otherwise be able to do is generally accompanied by some way of obliging them to do it.
yes, my lady.
General proposition. So,
I think I have the answer probably from your paragraph 53 in your written case, where you talk about the member of staff who's going to sell something, notwithstanding that it hasn't got a health mark. It's MS 178.
Well, that is correct, my lady, but a more direct answer to the lady's question is provided by the animal byproduct regulations, because if I may take them to you, they're in at MS 1237.
But before we get on to animal byproducts, because it's disputed as to whether they apply at all, you would normally expect with a rule like that there to be backup sanctions and indeed enforcement powers, often in relation to the goods in question. You'd expect that. You wouldn't just expect that because the OV or any other official, professional or otherwise, says something, that is enough to ensure compliance with the rule.
Well, compliance is assured under the animal byproduct regulations, because if the slaughterhouse operator refuses to surrender the meat, the OV has authority to issue a notice requiring its surrender.
Well, let's have a look at that. But is it a criminal offence, for example?
Yes, and it's a failure to comply is an offence.
Failure to comply with Article 5.1.
No, it's failure to comply with the notice issued by an OV requiring the slaughterhouse operator to dispose of the carcass as animal byproduct.
Can we just have a look at that, please?
Yes, of course. It's at MS 1237.
It's volume 2, tab 11.
10.
I think it's 11.
This is under the animal byproduct regulations.
So this is a different set of regulations altogether.
Well, I'm referring to the UK regulations, which implement an EU regulation. The EU regulation is 1069/2009, which is at tab 11, and the Animal Byproducts Enforcement England regulations 2013 are at tab 10.
Oh, yeah.
Now, usually, as my learned friend indicated, animal byproduct is disposed of consensually, but
I thought you disputed whether the carcass was animal byproduct at all.
well, he did, my lady, and I can make submissions on that point.
Well, you'll need to, won't you?
Well, I do need to, but I was
If I've taken you out of your course,
Yes.
Sir Alan, please stick with your plan. I'm just giving you a notice of the questions to which I would like an answer.
I'm obliged, my lady.
And if I can add to that, I'm still troubled by your paragraph 53 example. But you don't need to deal with it at this particular moment because it's on the same topic. It's remedies.
Yes. My lord, my ladies, my lord, the outcome that I've been describing is contested by the appellants by what may be described as the once food, always food argument.
Well, until somebody stops having the intention of supplying it for human consumption.
In the respondent submission, it may be that meat retains the status of food even after the OV has reached his or her decision, that there may be grounds for declaring it unfit for human consumption, and accordingly a health mark can't be applied to it. And the wording of Article 14 might suggest that. However, in our submission, what's clear beyond argument is that the OV's decision formally establishes that the meat may not be allowed to enter the market. And from the moment of the decision, the meat cannot any longer lawfully be intended for human consumption. So it now meets the definition of animal byproduct in Article 3, to which you were taken by my learned friend this morning, because the meat cannot lawfully be intended for human consumption, it has to be kept off the market. And any intention on the part of the slaughterhouse operator that the meat be for human consumption is irrelevant, and if executed would be unlawful.
Yes, but if he seeks to fulfil his intention by asserting a right of appeal, if such a right existed, what would be unlawful about that? I mean, clearly he can't put it on the market, but that is the gravamen of the complaint. They're saying we don't accept the OV's assessment. We want to put this, we intend to put it on the market if there is a means by which we can establish its good health.
That's in fact exactly what happened.
But my Lord, we say there is no such means, because it would be incompatible with the judgment, with the decision-making, the system of decision-making that is established by Regulation 854, and I will presently come to, I will presently make submissions to the effect that Article 882 doesn't provide any possible right of appeal against the OV's decisions. If I may reiterate that submission, that there's no requirement for anyone other than the slaughterhouse owner, as required by the animal byproduct legislation, to do anything except to dispose of it except to dispose of the meat safely. And there are powers which the OV exercised in this case to issue a notice that effectively binds the slaughterhouse owner to take that action. Can I be of further assistance to the court on that point, or shall I move on to our Regulation 882?
Well, you were referring, I think, to Regulation 25 of the UK regulation.
Yes, may I take it?
Which talks about the notices that may be
Yes.
served in relation to byproducts. But we still have this problem about whether or not a carcass has stopped being food and become a byproduct, and at what point that happens.
Our submission, my lady, is that it happens at the point where the OV refuses to, decides that it would be inappropriate for him to apply a health mark, because from that point, the carcass the meat from the carcass may no longer be placed on the market, and any intention to do so
Yes.
would be unlawful.
Unless there were lawful means by which that intention could be pursued. Which is the issue that we're here to deal with.
We're back to a certain amount of circularity, yes.
Yeah.
Well, that is correct, my lord, but it is our submission that Article 88, that Regulation 882 does not provide.
Yes. Perhaps we should need to go there. Could I just ask one question before we do that? It is said that millions of pounds worth of meat, if the meat was good, have to be disposed of because of OV decisions. How frequent is it in the FSA's experience that OVs are challenged? I mean, is this a regular thing, or is it a very unusual thing?
My understanding, I'm instructed, my lord, that it's a very unusual thing.
Yes.
That this is usually that the meat is usually disposed of consensually.
Well, it's demonstrably bad. Then the people just accept that, that the meat is bad.
I think, on the whole, the efficiency of the meat production system depends on a high degree of cooperation between the authorities and slaughterhouses, and I believe it's only very occasionally that there is a disagreement about.
But that may explain why
his judgment.
Why there is little evidence of a linkage between the marking of meat in the past and Section 9, because things were decided consensually. But anyway, I don't want to take you away from 882 because I know time presses.
Well, I'm sorry, I did answer. Thank you, Lord. If I may move on then to Regulation 882. Its title refers to official controls performed to ensure the verification of compliance with feed and food law, animal health and animal welfare rules. Now, may I take your ladyships and your lordships to recitals 4 to recital 4 of the preamble, which, together with recital 6 and 7, identify the broad objective of the regulation. Regulation 4 says, talks about the responsibility of FBOs themselves for ensuring that at all stages of production, processing and distribution by businesses within their control, feed and food satisfy relevant requirements of feed and food law. And recital 6 talks about the responsibility of member states. It says the member states should enforce feed and food law, animal health and animal welfare rules, and monitor and verify that the relevant requirements thereof are fulfilled by business operators at all stages of production, processing and distribution. Official control should be organised for that purpose. And then recital 7 says it's appropriate to establish at community, now union level, a harmonised framework of general rules for the organisation of such controls. So the objective of the regulation is to establish a harmonised EU framework for the organisation of official controls to enforce food law and verify that its requirements are fulfilled by FBOs. Now, may I turn to...
It's interesting, isn't it? I mean, recital 7, because it's saying it's appropriate. They're saying FBOs should do it, member states should enforce it. Well, obviously that's what happens. Appropriate to establish at community level a harmonised framework of general rules for the organisation of such controls, which is not general rules for the enforcement of such controls. It rather looks as if it contemplates that national law will actually deal with things like powers of search, seizure, criminal offences and the like, which you would expect.
Which you would expect, my lady. The EU legislation applied established a framework which the member states are required to implement. But if I may move on to Article 54, which is at MS page 935. I know that you've been taken here already by my learned friend, but there are some submissions that I with your permission, I'd like to make. It's our submission that both the context and the plain words of Article 54 show that it's about national enforcement measures of the kind referred to in Recital 6 to compel compliance by FBOs with food law. As to its context, Article 54 is contained in Title 7 of the regulation, which is headed Enforcement Measures, as you can see, in Chapter 1 of that title, which is headed National Enforcement Measures. And Article 54's own heading is Action in Case of Non-Compliance. Its companion provision in the same chapter of Title 7 is Article 55, entitled Sanctions. So the two provisions are about different ways of enforcing food law against those subject to it. Administrative measures under Article 55, 54, sanctions under Article 55. Now, as to the wording of Article 54, if I may take you to paragraph 1, in our submission, it's significant that the non-compliance which triggers the obligation for the competent authority to take action is that of an FBO, because the stated purpose of the action is to ensure that the operator remedies the situation. So in our submission, that the plain language of Article 54 shows that it's talking about member states' enforcement measures to bring about remedial action when cases of non-compliance have been identified. The second, and in our submission, that's confirmed by the second sentence, in deciding what action should be taken, the competent authority must take account of the operator's past record with regard to non-compliance. In other words, the operator whose failure of compliance is the reason why the action is required. So the article is all about dealing with identified instances of non-compliance by FBOs, and it's assumed that any action taken will be within the power of an FBO. And it may be true, as the appellants contend, that non-compliance may occur irrespective of any specific human action or fault, but that's not the sense of Article 54, which is about non-compliance measures to remedy non-compliance by FBOs. And in our submission, that is borne out by the long menu of enforcement actions in Article 52(4), paragraph 2. Now, my lords, my ladies, my lord, may I take you to Article 54, paragraph 3, which is the provision on which the appellants rely. It's common ground that Article 54 doesn't expressly impose a duty on member states to provide for a right of appeal against enforcement action, which is the enforcement action which it contemplates. The issue is whether paragraph 3 can be interpreted as doing so by reading it together with recital 43. Now, may I take you first to recital 43? This is at MS 894. In our submission, recital 43 has to be read in the context of recitals 41 and 42. recital 41 talks about the need for national measures as a deterrent to breaches of food law. Breaches of feed and food law and of animal health and animal welfare rules may constitute a threat, and such breaches should therefore be subject to effective, dissuasive, and proportionate measures. And recital 42 goes on to say that such measures should include administrative action by the competent authorities in the member states. In other words, consistently with the scope of Article 54, as I've just explained it, any possible inferences that can be drawn from Article 43 should be confined to decisions imposing enforcement measures to ensure compliance by FBOs with food law. And that, in our submission, follows clearly from those recitals, which are the recitals that underpin Article 54. Now, turning, if I may take you back to 54.3 at MS 936, my learned friend read it out, so I won't do that again. In the words of the Court of Appeal, that provision says only that the competent authority must provide the operator with information on its rights of appeal, whatever these may be. Now that's at MS page 221 in the judgment of the Court of Appeal. Article 43 is a recital, but it's only a recital. In itself, it can't create rights or impose obligations, though it may serve as a tool of interpretation. Now, to interpret Article 54, paragraph 3, in the light of Article 43 as imposing an obligation on member states to establish rights of appeal where these don't already exist in national law, would be a long step, even in the light of Recital 43. A perfectly viable interpretation of Recital 43 is that it merely constitutes encouragement for member states to provide for such rights. The appellant set great store by purpose of interpretation of Article 54.3, but without explaining how exactly this is to work for them. On their analysis of Regulation 882, which is not the respondents, the general duty they wish to interpret into Article 54.3 would have to be wide enough to include a right of appeal against decisions of the OV under the EU fresh meat regime. The case they would have to make, which they have not made, the case they would have to make would be that this was necessary in order to enable the purpose of Regulation 854 to be fully realized. In our submission, that's implausible, given the specific character of the fresh meat regime the EU legislature chose to create and the pivotal role given to the OV within it. Even supposing that Article 54, paragraph 3, provided expressly for a general right of appeal against decisions of authorized officers applying food law, it's scarcely conceivable that such a right could be interpreted as applying to decisions on health marking in the absence of clear language to that effect in Article 854 itself. In the respondent's submission, the purpose of interpretation of Article 54.3 in relation to Regulation 854 militates in the opposite direction, that there should be given the nature of the decision, the nature of the judgment which the OV is called upon to exercise, there should be no right of appeal, and if it were intended that there be one, this ought to have been provided for expressly. The only authority the appellants cite on purpose of interpretation is the famous passage in the judgment of Lord Denning, MR, in Bulmer and Bollinger. That Lord, if you would like to be taken there, it's at Lord Milady, it's at MS pages 1499 to 1500. Where Lord Denning talks about the differences between EU regulations and directives on the one hand and UK statutory instruments on the other. And at the end of the paragraph he says, in case of difficulty, recourse is had to the preambles. These are useful to show the purpose and intent behind it all. But much is left to the judges. The enactments give only an outline plan. The details are to be filled in by judges. Now, my lords, that may have been true of EU legislation at the time, particularly of directives, which tended to be very broad in their structure. But in our submission, it's no help to the appellants, because the hygiene regulations certainly give more than an outline plan. They are extremely detailed, and that's especially true of the EU fresh meat regime in Regulation 854. The appellants are seeking to use a recital in a different regulation, 882, to read into Regulation 854 a provision which, in our submission, goes against the grain of its express provisions. And it's our submission that this is an illegitimate, this would be an illegitimate use of purposive interpretation. If I can't be of further assistance on that point, may...
Well, you basically have to say, don't you, that the 854 prohibits the provision of a right of appeal on the facts or merits against the decisions of the OV, you have to say.
I do, my lady, because these are decisions that can only be taken on the basis of the professional judgment of officials who have to undergo special training, and as provided for by 854. So it is our contention that a right of appeal would be incompatible with the regime as laid down by that regulation. On the legislative history, lady, I've already made our main point, which that the appellants have been unable to identify any link in the history of the legislation between inspection and marking of freshly killed meat on the one hand, and an Article 9 type of procedure on the other. I've only one point to add to what's said in our written case. If I may take you to the Fresh Meat Hygiene and Inspection Regulations 1992, you were taken to them by my learned friend this morning. They're at tab 43, MS 2039. That's in volume 5. Now, these were these regulations implement Directive 91/497, which is at MS 2231. I think all I need to say about it is that it was a big consolidating directive that brought together all the amendments to the old Directive 64/433. There'd been a directive in force ever since 1964, which had been amended again and again. And 91/497 brought these amendments together in a rather odd form, because the legal effect is given to the instrument by Directive 91, is given to the EU regime by Directive 91/497, but the detailed rules are contained in an updated version of Directive 64, which is annexed to the operative part of the directive. Now, this was the last major reform of this branch of EU law before the adoption of the regulations in the early 2000s, the effect of which was to substitute directly applicable rules from those of the directives, which had to be implemented by member states. Now, the point I want to make is that the 1992 regulations distinguish very clearly between enforcement measures and the decisions on health marking that the OV is called upon to take. And they acknowledge the need for rights of appeal with respect to enforcement measures, but not to the OV's decisions. If I may show you Regulation 6, that's about appeals against refusal or revocation of a license.
Could you give me the page, please?
I beg your pardon. It's, my lady, it's 2045.
Thank you.
And that's about establishing a tribunal for appeals against refusal or revocation of licenses for slaughterhouses and other premises. And then, if I may take you further on to page 2047, Regulation 10. That's about enforcement measures of a kind which are broadly equivalent to remedial action notices under Regulation 9 of the 2013 regulations. It's about enforcement measures that may be taken for the purpose of enforcing the rules. And paragraph 5 provides explicitly for a right of appeal.
I'm sorry, could you just give me the page reference again?
Yes, my lady, it's 2047.
2047.
Paragraph 5 of
10.5.
10.5.
2048.
Paragraph 5 is actually on 2048.
Thank you very much.
The next provision on inspection and health marking is Regulation 11, and the detailed rules which implement that provision are set out in Schedule 12 to the regulations. I don't think I need to take you to those. They are broadly similar to the present fresh meat regime. The point that I want to make is that Regulation 11, in contrast with Regulation 10 and Regulation 6, says nothing about a right of appeal. And this in our submission, shows the understanding of the UK authorities of the distinction between enforcement measures and OV's decisions. It shows how they understood the requirements of EU law before these were incorporated into directly applicable regulations.
Or, of course, it could have shown an understanding that Section 9 applied, so there was no need to provide for something.
Yes, my lady. If time permits, I will make submissions as to the unsuitability of Regulation 3, of Section 9 for that purpose.
So you say that was intended to be carried through, Sir Alan? Is that right? Or that understanding is reflected in the scheme of the directly effective?
Yes. Yes, indeed. Yes, indeed, my Lord.
Sorry to take up a bit of time on this, but are you saying that it is implicit in the two regulations that we've looked at that there should be a right of appeal, but it's confined to enforcement action? Or are you saying it's such a strong thing to find a right of appeal that there's no right of appeal in relation to anything other than what the member state allows you?
Something in between the two, my Lord, that it's difficult to establish a right of appeal on the basis of Article 54.3, but if there is such a right of appeal, it certainly doesn't extend to decisions by the OV.
Right. That rather sounds as though you are intending to submit that there's no right of appeal at all for anything, but as a fallback, if and insofar as there is a right of appeal, it's just enforcement.
Yes, that is my
Right. Okay,
that is our position. Milady, I should say something at this point about the manual. I think I have referred your lordships to points 11 and 12 in the statement of facts and issues. The version I'm not able to. I have not been able to establish when the incorrect version first began to be used. It is incorrect, and even the current version is wrong in the reference that it makes to Article 54. But our main submission on this is that it doesn't matter, because the issue is law, is one of law, and I'm instructed that the object of the revision of the manual was to bring it into line with the FSA's new understanding of the implications of the EU regulations. I'm afraid that's the best that I can do on the manual. If I may move on, conscious of that time is running against us, on the 2013 regulations, I can be quite brief, because it's our submission that Regulation 25, read together with Regulation 29, simply provides for the purposes of those regulations the Section 9 procedure as one additional form of enforcement measure. It's our submission that the appellants exaggerate its significance. All it means is that the Section 9 procedure is being made available as an enforcement mechanism, which is there to be used when a power of inspection and seizure of suspected food is needed for the effective enforcement of the hygiene regulations, just like any other enforcement mechanism provided for by the 2013 regulations, such as hygiene improvement notices under Regulation 6 or remedial action notices under Regulation 9. It's just another form of enforcement measure. There's nothing whatever in the text of Regulation 25 to suggest that it's meant to convert Section 9 into a kind of all-purpose appeal procedure to supply supposed gaps in the EU regulatory scheme. There's plenty of work for the Section 9 procedure to do without providing a right of appeal against decisions by the OV. And at paragraph 53 of the respondent's written case, we give examples in which it's perfectly appropriate for various kinds of enforcement measures, including under Section 9, to be taken in slaughterhouses by OVs in order to ensure compliance by the operator with the hygiene regulations. That passage, which I don't think I need to take you to, is in our written case at page 177, at MS page 177. If I may.
Well, how does the example that you give in the third sentence, is it? Similarly, supposing that in the course of an audit, meat lacking a health mark was discovered, which the operator or some other member of staff had put to one side with a view to selling it. Regulations 25 would enable an authorised officer to seize the meat and submit it to a justice of the peace for condemnation under the Section 9 procedure. Now, why should that apply in the course of an audit, but not in the course of a standard process of inspection?
Because, my lady, it's simply a matter of discovering meat which lacks a health mark. It's not an operation which involves the exercise of specially trained professional judgment. It doesn't even need to be an OV. In practice, it will be an OV because that's what the regulation says. But it doesn't. It's different. It's not the kind of decision which the OV has to make when freshly killed meat has to be. When the condition of freshly killed meat has to be determined in order to ensure that it can be released onto the market safely. I hope that answers.
Yes, it's not actually, that limitation is not inherent in Regulation 25. You say it's inherent in the EU Regulation 854.
Well, in our submission, the EU regulation sets the conditions on which meat can be allowed onto the market. If those conditions are not satisfied, and that depends on the judgment of the OV, then the meat may not be allowed onto the market and has to, because Article 5 says so, and it will then have to be disposed of as animal byproduct, if necessary, in response to a notice from the OV, should the slaughterhouse operator not be willing to release it voluntarily.
Would there ever be an occasion for seizing it and taking it in front of the Justice of the Peace in those circumstances?
Not, my lady, when it's a question of the OV's judgment that the condition of meat is that the meat is such.
Yes, but I'm postulating the situation in which the operator just doesn't do what he should do.
Oh, my
And
lady,
so you're saying serve a notice, etc.
I mean, yes, if the operator doesn't dispose of the meat as the regulations requires that he should do, then the OV has to issue a notice, as happened in this case.
Yes, and ultimately, if it doesn't resolve itself,
He
would there
doesn't-
be an occasion to take it in front of the justice? Would it be
There
an
would
occasion
an-
to seize it?
But the refusal to comply with the notice is an offence.
Yeah, so the notice in this case was a byproduct notice, was it?
Yes, my lord.
Well, that's of course part of the point,
Yes.
which is why I was asking the earlier questions.
Yes. So you can taking the Black's position, you can take enforcement action. You've got a situation where the FBO disagrees with the OV, the FBO doesn't surrender the meat, then the competent authority issues a byproduct notice, which has to be complied with, which failing a criminal offence. And there's no appeal against that byproduct notice?
Well, there would be a prosecution, my lord.
There'd be a prosecution.
And that would follow.
That seems to be crossing the line well into enforcement. Yes.
But if it was the case that a member of staff had put to one side meat without a health mark, and that was discovered on an audit, could the Section 9 procedure be used in those circumstances?
Yes, indeed, my lord. If I may move on quickly to the issue of to my third main submission, which is the unsuitability of the Section 9 procedure for the purpose to which the appellants argue it should be put. There is an argument first about the scope of the Section 9 procedure. The respondent disagreed with the interpretation that the appellant offer of the conditions contained in contained under subsection 1B of the section of Section 9. The wording on which the appellants rely is possession for the purpose of preparation for sale. In our submission, the Court of Appeal was right to take the view that it did, because prior to the application of the health mark, the carcass can't be said to be in the possession of the slaughterhouse operator for the purpose of preparation for sale, since it hasn't yet reached the stage of being saleable as meat intended for human consumption. It hasn't yet reached that stage, so it can't be said that it's being held for preparation for the purpose of preparation for sale. It will only reach that stage once it has been health marked. Up to that point, it remains uncertain whether the meat will be put on the market for sale or disposed of as animal byproduct. At the stage of the post-mortem inspection, the carcass is possessed by the slaughterhouse operator for the purpose of the verification of its fitness to be placed on the market. Once the meat has been health marked, then the preparations for sale can begin. The respondent contends that the Section 9 procedure and the EU fresh meat regime of Regulation 854 are completely incongruous. They simply don't fit together. Hence what the Court of Appeal says about the need for substantial amendment to Section 9 that would be needed to accommodate the EU regime. The main incongruity is that Section 9 gives the power of final decision to the Justice of the Peace. Not to the OB, but to the Justice of the Peace. Now, as I submitted a little earlier, this is no reflection on the ability of Magistrates' Court. It's simply that a different kind of decision, the weighted double negative decision, as the judge described it, is prescribed by the regulation. So that's one important element that the Article 9 procedure cannot reproduce. The kind of informed expert, the finality of the decision taken by a specially trained expert. And what's more, the authorized officer doesn't take a decision which can be appealed. The decision-making process is a two-stage one. The authorized officer seizes the meat, but it's the Justice of the Peace that actually decides what should happen to it.
It's almost as though the authorised officer is a sort of prosecutor. They bring the meat before the magistrate, and the magistrate takes the decision.
Exactly, my lord. It's the Article 9, the Section 9 procedure is not an appeal procedure. It's a two-stage decision-making. It's not the decision by the justices is not an appeal from a decision taken by the authorized officer, because he doesn't decide anything. Under the EU regime, the OV doesn't serve notice or seize the carcass. He or she simply reaches a decision on the issue of fitness for human consumption and applies or refuses to apply a health mark accordingly. No one else is authorized to take that decision. There's no room for the JP for justice to displace the OV as the decision maker under a system which is designed to be swift, as it needs to be for operational and commercial reasons, but also to provide the necessary measure of public health protection.
So, Alan, I don't know how much time you were planning to leave to Mr. Heppenstall, but you've now got less than 15 minutes left between you. So,
thank you, my lady. I have been conscious of the clock ticking.
I do this to everybody, Sir Alan. Don't worry.
No, and I'm grateful, and I think that I can stop there, because I have made the essential point about the Section 9 procedure, that it may be a jolly good procedure for seizing food and dealing with it, but it doesn't work as an appeal system in respect of decisions by the OV under Regulation 854. If I can't be of further assistance to the court, I will cede my place to Mr. Heppenstall.
Thank you, Sir Alan. Mr. Heppenstall.
My lady, members of the court, actually, before I deal with some submissions and reply on the human rights points, can I just try and plug some of the legislative gaps that I feel that the court has been looking for in the course of Sir Alan's submissions? For example, my Lady Hale asked about, is it an offence to have a carcass on the market with a health mark, without a health mark? The answer is yes.
I
And-
assumed it would be, but it's
Yes.
nice to know where I find it.
Well, MS page 1178, these are the 2013 regulations.
Yeah.
Regulation 19.1 makes it offence not to comply with any of the specified EU provisions.
Yes, but I was looking in those.
Right,
and
well,
I couldn't find.
MS 1191, let me end your quest. And at the bottom of MS page number 1191, conveniently we find Article 5.1 of Regulation 853/2004, which is the requirement that FBOs do not place on the market a carcass without a health mark. So that creates the offence. Whilst we're at page 1178, you'll also see at Regulation 22, the domestic implementation of rights of appeal against enforcement action, such as you might find under Article 54 of 882. So the domestic implementation of the rights of appeal against enforcement action are actually at Regulation 22.
Sorry, the page that was.
MS 1179, just over the page from the offences. The other matter, my Lady Black was asking about what happens if the animal byproduct notice is not complied with. If one looks at MS 1238, Regulation 25, sub-regulations 3 and 5, the consequences are, and this is actually set out in the animal byproduct notice that was served in this case, which is at MS 457, the FSA will dispose of the carcass at its own cost and then recharge that cost back to the FBO. And if there's been an intentional failure not to comply with the animal byproduct notice, then it's an offence. My Lord Hodge asked about statistics. I think they're summarised in the SFI, but the underlying evidence about the frequency with which the processes we're concerned with here actually come to pass are at MS 560.
560?
Yes. Which is the evidence which will learn judge, which leaves 10 minutes to deal with the small matter of human rights. But actually, in a sense, when my Lady Hale put to my learned friend Sir Alan that the case we are making, the case as found in the Court of Appeal, is that Regulation 854 prohibits a right of appeal. And if you accept that that is the starting point, then all of the human rights arguments fall away, because Regulation 854 is a primary piece of EU legislation passed by the EU legislative institutions. It is they that have made the fundamental policy choice not to provide for a right of appeal. And once you're in that territory, not even the Supreme Court of the United Kingdom can do anything about it, apart from perhaps make a reference to the Court of Justice of the European Union, because a primary piece of EU legislation cannot be declared incompatible with fundamental rights by even the Supreme Court of a member state. We know that from the Photo Frost authority. And this court's interpretation duties under the Human Rights Act or under the Mar-leasing duty to make sure that our domestic legislation complies with EU legislation does not apply to primary EU legislation.
But I thought it was accepted by Sir Alan that judicial review would apply. I appreciate there's a difference between judicial review and a right of appeal.
Well,
he didn't suggest that that was excluded.
Clearly, the OV is a public officer making a decision. We can't say it's not amenable to judicial review. But as my learned friend Mr. Hercock submitted to you, they're not looking for a judicial review.
Yeah.
They're looking for a second opinion, in truth. They're looking for something that I don't think a magistrate...
They're looking for a possibility of challenging the decision of the OV on the merits, no doubt by reference, as you say, to an alternative view of the health of this animal from another suitably qualified person.
Indeed.
A determination by a neutral judicial officer. That's what they're looking for.
Indeed, my lady, but the fundamental submission is that the policy choice which has been made, and it finds its expression in Regulation 854, is not to make such provision. And this court can't
Well, you have to go further than that. You have to say it prohibits it.
Indeed, and we do, my lady, because it's not in Regulation 854, and you can't look for it in Section 9. And the reason you can't look for it in Section 9, first of all, as I've said, this court doesn't have the interpretation jurisdiction, because 854 is a primary piece of EU legislation, and you cannot do by the back door what Photo Frost shuts out by the front door. You can't go creating a right of appeal in Section 9 in a domestic piece of legislation in order to cure a human rights deficiency in a primary piece of EU legislation. Because you would actually create a factor-tame situation, because we'd end up with the member state having created a right of appeal through, say, Section 9, if that was possible. We say it's not, because as Sir Alan has just submitted, its architecture doesn't suit itself to the right of appeal. It's actually transferring the decision from the OV to the magistrate. But and in fact, that's the point. The European Commission would no doubt say that the United Kingdom is not following Regulation 854 because it's effectively, through the Supreme Court of its member state, transferred the decision-making power from the OV to the magistrate. So the human rights arguments don't go anywhere because there is no jurisdiction in this court to either use powers of interpretation which it doesn't have to create a right of appeal out of Section 9, or I think as the appellants put it in the alternative, they want you to declare that there should be some legal mechanism out of the ether. Now, if we're wrong about all of that, our alternative position is, in any event, there is no violation of Article 1, Protocol 1, or Article 17. And it's for that reason that we'd say the position is at Clare and that you shouldn't make a reference, because there's nothing to make a reference about. My learned friend took you to authorities which are actually about confiscation of valuable assets from the citizen to the state, either because they're the proceeds of crime or because there was some breach of planning duty or whatever. But here we're actually dealing with the control on public health grounds of something that actually, once the OV refuses to apply a health mark, doesn't have any value, or has very limited value. And we would commend to you
that's the very reason that it's being said that there should be means of challenge, because it's that act of the OV that turns a valuable, possibly a valuable asset into something which isn't worth anything.
It does, but the key is the OV is doing it on public health grounds using that double-weighted decision. And we, rather than this being the confiscation of an asset because you want to build a motorway, or because the state is asserting it's the proceeds of crime, for example in the Agossi case, or the Michael Intellect case where the alcohol was sold without a licence. These are very different factual situations. And in the case which we put in the bundle of Booker, tab 17, and given the time I'm not going to go to it, but it's a MS 1426. The case is a Scottish case that went to the Court of Justice of the European Union about the...
I'm familiar with it. I was the Scottish counsel who lost.
Well, I'm very grateful for that, then I don't have to labour the facts, but there was a destruction of all the fish in a fish farm, and there was no compensation available, and the Court of Justice of the European Union said that that was not a violation of Article 1, Protocol 1, or the relevant fundamental rights within EU law, because, as the Advocate General said at paragraph 93 of his opinion, you are poles apart when you're considering that sort of public health action from the situation where you have the appropriation of a private person's property by the public authority, such as the compulsory purchase of a building. There is no transfer of ownership in property of definite economic value to satisfy the need in the general interest. There is only property which, even if it may possibly still hold some economic value, must be eliminated, which therefore no longer has any prospect of being sold for profit. So just as the Advocate General and the court in that case was drawing a distinction between confiscation and controlling property. I think the Advocate General concedes it's extreme control because it's going to be incinerated, such as Carcass 77 was in this case. But he's drawing a distinction between the confiscation authorities that my learned friend puts before the court and the situation where we are in. So we say that if there is clearly an interference with Article 1 property rights, they're justified clearly on public health grounds. And because we've got an OV exercising his professional judgment on the double-weighted negative test, in order not to arbitrarily remove property from the citizen to the state, property of value, but to make sure that contaminated food doesn't enter the food chain, there is no need for any right of appeal or challenge. There is no unjustified violation of Article 1, Protocol 1 or Article 17. So we say, in summary, that the appellants have actually got the wrong starting point. There's no violation. And secondly, they've ended in the wrong place because we're here dealing with Regulation 854, a primary piece of EU legislation, which is off limits to this court. And this court has no jurisdiction to interpret Section 9 or any other piece of domestic legislation to create a right of appeal that the EU legislative institutions chose not to create themselves. I hope that deals as swiftly as possible with the human rights arguments in this case.
Remarkably swiftly.
For that to work, don't you have to say not that the EU chose not to create a right of appeal, but that they ruled out a right of appeal?
Well, we must so presume, my lady.
But that's what you have to say to make
Yes,
this
in
work.
fact, I was very grateful that my Lady Hale put our case so shortly to Sir Alan. Bluntly to Sir Alan, because that is also a very short answer to the human rights argument.
And the Court of Justice also in paragraph 93 ruled that the ordering of destruction of the fish without compensation was not an interference with the A1P1 right.
Indeed, drawing the distinction between confiscation, where there's always, nearly always, compensation.
It was the health grounds. The health grounds seem to be their most important.
Indeed, but of course,
it was about the destruction without compensation.
I mean, Lord.
Yes, you weren't being deprived of your property under A1P1, albeit you were being deprived of your property by their destruction. But it was treated as control of the property on health grounds.
I mean, it's interesting in that case that actually, as the Advocate General comments, there was no risk to human health. The risk actually was to other fish farms, whereas, of course, we're in a very different position.
That's correct.
Carcass 77, where the OV is trying to keep out of the food chain food of which there is doubt, it's double-weighted, that it would pose a risk to human health. So it's a fortiori justified in our case. I don't know if I can assist you any further.
Thank you, Mr. Heppenstall. Thank you. Mr. Holden.
Please, you, my lady. My main task in the next 15 minutes is going to be to analyse the respondents' answer to our submissions and offer a critique of them. And I shall go through the points that Sir Alan made, probably about a dozen points, and deal with them. Can I deal perhaps with two preliminary points? First of all, I'm going to work on the basis, if I may, and I'm sure your Lordship will correct me if I'm wrong, that I don't need to deal any further with the agency point, and I see your Lordship confirming that, so I'm grateful for that, and I won't go over that ground. Secondly, since we've just been talking about the matters that were debated between Mr. Hercock and Mr. Heppenstall, I don't want to say a great deal about those, but just to put this into context, if I may, it may be helpful to say this. First of all, Mr. Heppenstall has really made no bones about the fact that his case is, and has to be, that the EU legislation, and in particular Article 854, excludes a right of appeal for all purposes. They have to put their case as high as that in order to succeed.
Yeah, but not a right of review. So there's a difference between appeal, which is something on the merits, where someone else becomes the primary decision maker, which would be the case if Section 9 applies, and judicial review, where the OV would remain the primary decision maker, but there would be review to see if he'd behaved irrationally or something like that.
Well, my Lord, we had that discussion this morning, and I don't want to go over that ground again.
Certainly.
I don't need to go so far. I don't need to deal with that particular kind of review, because my case is that there is a right of review, appeal, challenge on the merits, whatever label one cares to ascribe to it. And of course, I can succeed if any one of the following propositions is true. First of all, Article 854 does not preclude a right of appeal. They have to show that it does preclude a right of appeal. It's sufficient for me to show that it does not preclude it. In other words, either that it supports, taken together with Article 882, taken together with Regulation 882, supports a right of appeal, or alternatively, it certainly doesn't preclude a right of appeal. So either or both of those two propositions would suffice for my purposes. Alternatively, that at the very least, the European legislation did not mandate a change in pre-existing domestic law, and that the ambit of Section 9 remains the same. And on any of those bases, we submit that we are entitled to rely, as my learned friend Mr. Hercock succinctly demonstrated, on the EU Charter and on the Human Rights Act. And it is only if Mr. Heppenstall is right in his ambition to say that EU law entirely excludes any right of appeal, that other arguments fall away. But of course, if he's right about that, then the argument no longer arises. Now, can I, while I've got it in front of me, and while perhaps the court has it available, let me just refer briefly to the Booker case, which is in Volume 3 at MS page 1426. That's where the references arose. And I just want to draw attention, if I may, to paragraph 98.
Is this in the AGO?
Yes. Because paragraph 98, in which the Advocate General pointed out that in a different case, not the one which was before the court, not the one which my Lord was arguing, as it were, the Advocate General pointed out that in a case in which draconian measures are imposed without payment of compensation for preventive reasons, then there has to be a balance between the public interest pursued and the extent of the sacrifice imposed on the farmer, whose farm is free of any contamination, and whether that might tend towards the payment of compensation. And the Advocate General is clearly expressing the view that in those circumstances the balance might favour the payment of compensation. And if it might favour the payment of compensation, then it might equally favour the kind of procedural remedy that is advocated in many of the authorities to which Mr. Hercock referred. So that the case does not rule out, the opinion of the Advocate General does not rule out the balance, a balance having to be struck between the public interest and the extent of the sacrifice imposed on the farmer. And our submission is, and I'll make this submission, I'll illustrate this as we go along in response to Sir Alan. Our submission is that the public interest would not be harmed to the slightest extent by allowing a right of appeal in these rare cases and by allowing resort to Section 9. And there is no reason to suppose that there would be any detriment whatsoever to the public interest in that circumstance.
But I thought Sir Alan's response to that is there is a detriment because instead of getting a trained expert deciding the matter, you get an untrained Justice of the Peace deciding the matter.
But only on the basis of the information and the evidence that is put forward by trained experts. So, but at least there would be the opportunity for, in a case of dispute, for an alternative expert view to be put forward, for the reasons for the opposite diagnosis being given to be expressed, and for somebody independent to make the decision. And that is not in any way contrary to the public interest. On the contrary, it is in the public interest, in cases of dispute, for there to be an independent view as to which diagnosis is correct. Now let me, because I have very little time left, let me briefly review the points made by Sir Alan, and let me go back to the four key elements of the OV's decision-making process to which he referred. Firstly, he said that this was that the decision by the OV was a decision as to the extent to which, if I noted his submissions correctly, a decision as to the extent to which the carcass complied with the requirements of the regulation. Our submission is that does not represent a true distinction, because in any of the examples that have been put forward, and I think I'm referring here in part to some of the questions raised by my Lady Black, in any of the examples that are put forward, that distinction could arise. That issue could arise. One can't rule out an issue as to the fitness of the meat arising in relation to any of the issues, including those that are raised in cases where there is admittedly an appeal. Mr. Heppel-Sauls referred to an appeal under the regulations, or in cases in which enforcement takes place. So there is no valid distinction to be drawn on that basis between the cases in which the FSA admit that there's an appeal and those cases in which they deny that there is. Secondly, Sir Alan pointed out that on his interpretation of the law, the official veterinarian has a monopoly. We say very, very strongly that is an entirely circular argument. It is very characteristic in our respectful submission of the submissions by the FSA that they assert repeatedly that the OV's decision has to be final because it is final, or is final because it has to be final, and that doesn't, with respect, take them anywhere. The third submission was very much along the same lines. The fourth submission about his qualifications, as I've said, doesn't take them any further because the JP would inevitably pay great respect to the views of any qualified expert, and nobody is for a moment suggesting that the appeal process would be a way of, as it were, going behind expert views. The next point that arose, according to my note, was the rather extraordinary position that since we know, and there hasn't really been any serious dispute about this, that since we know over a long period of years that within our jurisdiction, the Section 9 procedure applied, or at least could apply as a matter of law, to cases in which inspection suggested that the meat was unfit. That would inevitably mean that the law changed in 2005 when, on their interpretation, the EU regulations came into force. And as I submitted in my opening, it is absolutely extraordinary that this change of the law occurred on their case without anybody noticing. Not only did the industry not notice, the regulator didn't notice, the Secretary of State didn't notice, otherwise he would surely have promoted regulations of the kind that we've seen, the 2013 regulations, in a very different form from that in which they are. And that, we submit, is a line of argument that strongly supports our position. Then he said that there was no evidence that the procedure was actually used, to which I respectfully adopt the answer. Indeed, it's an answer I gave in my own submissions, that the pre-existing manual is strong evidence of what that pre-existing procedure was, and it is for the regulator to adduce evidence if they want to say that the manual wasn't applied, or that it was incorrect, or that it was appreciated that it was incorrect. An issue then arose as to the fact that the Section 9 procedure, and the procedure which we say is now mandated under Regulation 882, involves both inspection and enforcement. And again, I think it was my Lady Black, who pointed out that those two things go hand in hand. And the problem for my learned friends is that if they say that Regulation 854 involves inspection only, and that there is no role for enforcement, then that doesn't explain the existence of the powers in Regulation 882, or indeed the existence of the powers in Section 9. Then we came to what is perhaps one of the most important points in the case, which is their analysis in relation to animal byproducts. They still have no answer to our argument on that. The meat was not animal byproduct when it was dealt with in the slaughterhouse. It was not even animal byproduct after the decision that it was unfit. And can I take you, please, because it's important to see exactly what they said in their written case. It's at MS 183 to 184 in paragraph 70 of their written case. I quoted from this earlier, but I didn't take you to it. Referring to Article 14 of Regulation 178, they say this: the appellants correctly observe that the wording of Article 14.2b suggests that food that is unfit for human consumption is nonetheless to be considered food. It follows that at the point immediately after the animal was slaughtered, carcass number 77 technically constituted food. Further, it remained food once the OV declared it to be unfit for human consumption.
Well, Mr. Hockman, you've more or less run out of time. I'm not sure whether that isn't quite a good peroration for you.
If your ladyship considers that that is a good
Well, that's
place,
not an indication of whether I accept it or not.
No,
Simply an
of course
indication
not. But if you think it was a good peroration, then I'm more than content.
Well, thank you all very much indeed. I do feel for the poor carcass that had achieved the best price at the Darlington auction mart, which I know well, and then very shortly thereafter was declared to be worthless. Poor beast 77, I think. But we'll go away and work out what on earth the answer is to the intriguing issues of law that you have all put before us, and thank you all for your submissions.